Nonprofit and government-owned healthcare entities may qualify to be tax-exempt under federal law. Qualifying for tax-exempt status provides many benefits. One of the most significant benefits is not having to pay federal income tax. A tax-exempt status also makes fundraising easier because the entity may be able to issue tax-exempt bonds, and donations to the entity are tax-deductible for the donors. To qualify for federal tax exemption, a healthcare entity must satisfy the requirements set out in Internal Revenue Code Section 501c3. If the entity is a hospital, the hospital must also satisfy a second, overlapping set of requirements in Section 501r. We'll start with Section 501c3's tax exemption requirements. To be tax exempt under Internal Revenue Code Section 501c3, an entity must have one of the qualifying purposes listed in that code section, such as a religious, charitable, or educational purpose. The entity's organizing documents, such as its articles of incorporation, must limit its activities to this exempt purpose, and the entity's operations must primarily serve its exempt purpose. By itself, providing healthcare isn't a qualifying purpose. Thus, if a healthcare entity qualifies as tax-exempt, it's usually by having a charitable purpose. This method is so common that the Internal Revenue Service has a specific standard for determining whether a hospital is operated for a charitable purpose, which is called the Community Benefit Standard.